Thanks very much, Vanessa. Well, that's a sort of recap on the default, if you like, contract law position. We're now going to move on to look what happens when you start introducing in your contract some of these specific expressions, which are the main thrust of our webinar today. Alex is going to look at warranties, conditions, and representations. Alex.
Thank you, Jonathan. This afternoon, I am going to look at the topic of warranties, covering in particular the differences between warranties and conditions and warranties and representations, both of which are areas which are often rife with confusion and, in my experience, the bane of many lawyers' lives. Indeed, the term warranty has been described as one of the most ill-used expressions in the legal dictionary, quite an accolade, and it would be fair to say that there is often much confusion between the terms warranty, condition, and representation. So I'm really going to go back to basics and try not to fall into the trap myself of misusing the term. A warranty can be defined as a contractual statement, or, to put it another way, a contractual assurance about a specific state of affairs. It is quite simply a promise enshrined in a legal agreement. TLC, a key know-how resource and daily lifesaver for most lawyers, has defined the term as an assurance or promise in a contract, the breach of which may give rise to a claim for damages. It is essentially a minor term of a contract. So why go to the trouble of drafting warranties into your agreement? Quite simply, warranties provide comfort. Failure to comply with the specific warranty will give rise to a right to bring a claim for breach of contract. So to this extent, expressly setting out specific warranties provides protection and clarity about the circumstances which may give rise to a claim. The premise is also, in an asset or share purchase context, that the threat of the potential claim for breach of warranty should encourage the seller to disclose any potential problems and flush out any known issues during the negotiation process. If a claim for breach of warranty is pursued, the onus is on the claimant to show evidence of the breach and evidence of loss caused by the breach. There is a duty on the claimant to mitigate their loss, and I'll say a little bit about this later. It is worth flagging that warranties are only as good as the seller giving them. In a situation where an individual does not have the means to meet any potential claims for breach of warranty, or where a corporate seller is at risk of insolvency, the warranties provided could be rendered worthless, however comprehensive they may be. Therefore, care should be taken to ensure that the warranty is backed by an entity that will be around to pay out for breach of warranty, so for example, by requiring a bank or parent company guarantee as applicable. I have mentioned throughout this presentation that the remedy available to the innocent party for breach of warranty is damages. As a warranty is not considered a fundamental term of the contract, the party will not be entitled to terminate the agreement unless there is express drafting which stipulates that the breach of warranty which gives rise to the right to terminate. So if you want to afford yourself the opportunity to terminate the agreement for breach of warranty, because remember, starting point is that the only remedy available for breach of warranty is damages, is to ensure that your agreement specifically asserts that breach of warranty under the agreement will give rise to the right to terminate the agreement. In other words, you must elevate the status of the contractual warranties to material terms of the agreement which give rise to the right to terminate. The onus is on the claimant to establish loss. Only then can a claim for damages be made. The legal position is that the damages available will be that which puts the claimant in the position they would have been had it not been for the breach. Damages for breach of warranty are calculated on a contractual basis and so aim to put the claimant in the position they would have been had the warranties been true. As I mentioned earlier, I would also comment that the claimant is under a duty to mitigate their loss. In other words, a claimant cannot recover damages for any part of their loss which could have been avoided by taking reasonable steps. As I mentioned earlier in the presentation, the terms warranties, conditions, and representations are often used interchangeably, both orally and in the context of contractual drafting. The differing meanings and implications of misusing a term incorrectly can have profound implications on the rights and therefore what is recoverable. So it is important to have the distinctions clear in your mind, or failing that, an awareness that the terms are distinct, and these handy tables up on the following slides to remind you of the differences. In respect of warranties and conditions, a warranty is in the contractual pecking order less important than a condition. A condition is a fundamental term of the contract, whereas a warranty is simply an assurance within a contract. Given that a condition is a fundamental term of the contract, the remedy for breach is that the claimant is entitled to rescind or affirm the contract as they so choose and or claim damages, whereas for breach of warranty, generally the only recourse available is damages. And I've just noted on the slide there that in some situations where there has been a breach of a condition, the claimant may not necessarily wish to rescind the contract and may wish to either continue treating the contract as continuing, so affirm it, or simply to pursue damages. Finally on this slide, I've noted that a breach of warranty can be drafted so as to give rise to the right to terminate the contract, but I have noted, unlike a condition, this is an express drafting right as opposed to an automatically arising legal right, which is afforded to conditions. Now for the difference between warranties and representations. As I have said, a warranty is a statement of affairs, a contractual assurance which is incorporated into a contract. A representation is a statement of fact or opinion which typically precedes the drafting of a contract and usually does not form part of the contract. The statement must have induced the party to enter into the contract. A claim for breach of representation will usually be a claim in tort, whereas a claim for breach of warranty will be a contractual claim. To be successful in claiming for a breach of representation, the claimant will need to establish whether the claim is fraudulent, negligent, or innocent, which will govern what remedies are available. Just very briefly, to succeed in bringing a claim for fraudulent misrepresentation, the claimant must establish that the representation was knowingly falsely made or without belief in its truth, or recklessly as to its truth. The remedies available are damages, with no remoteness limit, and or rescission. A negligent misrepresentation occurs where a statement is made by one contracting party to another, carelessly or without reasonable grounds for believing in its truth. Test is an objective standard. The claimant can claim damages and or at the court's discretion rescind the contract. An innocent misrepresentation is used to describe a misrepresentation made entirely without fault, i.e. where the maker can show that it had reasonable grounds to believe that the statement was true. There is no right to damages for an innocent misrepresentation unless the courts order it. The usual remedy in this case is rescission. To conclude, a claim for breach of warranty is a contractual claim, and the remedy will be to put the claimant in a position had the contract been properly performed, whereas a claim for breach of a representation is a tortious claim, and the aim is to put the claimant in as good a position as if the tort had not occurred. And just to mix things up a little bit, I thought I would quickly cover off the implications of including drafting in an agreement which sees the terms representation and warranty used in conjunction. So along the lines of what I put up on the slide there, it is not uncommon to see the drafting X represents and warrants. In doing so, this gives the receiving party of the warranty two potential remedies, one being a tortious claim for breach of representation and the other contractual for breach of warranty. As I said earlier, representations are typically statements which precede the formation of the contract. Including such wording incorporates the representation into the agreement. Indeed, the role of representations can be severely restricted if they are not incorporated into the contract and the contract contains an entire agreement clause. Typically, an entire agreement clause is a clause in an agreement which states that the written contract sets out all of the contractual obligations and liabilities of the party, and that there are no additional terms. Pre-contract representations will often be explicitly referenced in an entire agreement as falling outside the agreement. If drafting such as that up on the slide there is included in a contract, an entire agreement clause will not preclude representations made, as by virtue of the drafting, they are incorporated into the agreement. So in summary, if you are the person or acting for the person giving the assurances, you would seek only to use the word warrant so as to limit the exposure of those representations that have been made. Conversely, if you're the person or acting for the person receiving the benefit of the assurances, you would strive to have the clause include reference to represent, such as that set out on the slide, to afford yourself luxury of the two remedies options. So finally, I set out on a crib sheet for you to use going forward, a little help sheet to help you avoid falling into the trap that plagues so many lawyers. It sets out the brief definitions of each of the terms condition, warranty, indemnity, and representation. And on that note, I'm going to hand you over to Jonathan.
Thank you very much, Alex. Well, following Alex's analysis of warranties and the difference between warranties and conditions and representations, I'm going to look at indemnities, including differences between indemnities and both warranties and guarantees. So let's start with the question, what is an indemnity? An indemnity is a promise to be responsible for another's losses. If A promises to indemnify B for the consequences of a specified event, and that event occurs, then B can ask A to make a monetary payment to cover the loss that B suffers. This typically happens where A can create that risk of a loss which B would otherwise have to bear. One common example is the third-party intellectual property, or IP, indemnity. For example, A licenses its software to B. If A's software infringes the IP of a third party, then B, as a user of that software, could also be in the firing line for a claim by the third party. So A indemnifies B to the effect that if B suffers a loss as a result of a third-party claim, then B can pass that loss on to A. That's an example of the use of an indemnity to provide for an allocation of risk where the parties want to contractually alter the default position because they've agreed that one party shouldn't have to bear a particular loss. However, indemnities are also sometimes used as a form of backup in relation to a breach of contract, which might be either for a specific breach or generally for any breach of contract. Why is this done? After all, as we've already heard from Vanessa, if there is a breach of contract, then the innocent party has a range of remedies available, including a right to claim damages for the loss that it suffered.